Hello and good afternoon. Thank you for joining us today. My name is Sana Salim, and with me here today I have Chelsea Glover and Christina Jump. We're excited for today's topic. This is now the third in a series of webinars that MLFA has hosted with regard to mosques and more generally nonprofits. Today's topic is worker classifications in mosques. We all know that mosques and other religious organizations are not thought of as a business, but they still do need to think about employment liability and employment law matters when it comes to hiring employees, classifying employees versus independent contractors versus volunteers, compensating employees, terminating employees, and establishing payroll. So we're excited for you to join us as we dive further into these employment law topics so that your mosque and or nonprofit organization can operate as smoothly as possible. With that, I'd like to introduce our first speaker. Chelsea Glover is a senior staff attorney for MLFA's Civil Litigation Department. She joined MLFA in 2023, and she primarily works on race and religious discrimination in employment, education, and public institutions. She received her JD and LLM in International and Comparative Law from Duke University School of Law and has been practicing law in Texas and the federal court since 2015. Before joining MLFA, Chelsea primarily worked in commercial litigation with a focus on antitrust and employment law. She also worked on pro bono immigration appeals, Violence Against Women Act, or VAWA petitions, and special immigrant juvenile status applications. So we're so excited to have Chelsea's expertise and the wealth of knowledge that she brings with us today. And we also have Christina Jump. Christy is our Civil Litigation Department head. She's been with MLFA for over 8 years now, and she brings nearly 30 years of federal litigation experience with her to MLFA. She does appellate oral arguments, federal court trials, and federal administrative trials. She is also certified as a civil litigation mediator. Christy has brought so much pride and joy to MLFA by being named a super lawyer in Texas by Thomson Reuters for many years now. She is also board certified in labor and employment law by the Texas Board of Legal Specialization, and she's had that since 2001. So thank you, Christy, also for joining us. And with that, we will go ahead and get started on today's presentation.
Thank you, Sana, and thank you everyone for attending. As you can see, today's presentation will be about worker classifications, employee classifications, and what you need to know as a mosque or as a religious nonprofit. Next slide, please. So why do we classify workers? The simple reason is that the law requires us to classify different categories of workers to determine what rights they have. Today we're going to talk about the federal laws that apply, but note that there are certain state wage and hour laws that apply, and they may have different requirements. So you definitely want to reach out to a state employment attorney with expertise in those matters. Today we'll be talking about the IRS, the Internal Revenue Service, which regulates and collects taxes, and the Department of Labor, specifically with the Fair Labor Standards Act, which is called the FLSA. And it governs wage and hour for any businesses or employees who are involved in interstate commerce. And it has certain minimum wage requirements and overtime requirements. And so just brief overview, the IRS treats employees differently from independent contractors, for example. It treats volunteers differently. And so any kind of money that you give or gifts, for example, that you give to certain classifications of workers will have to be reported differently, and the taxes that you owe on those payments will be different based on what kind of worker they are. And IRS has specific laws for determining what kind of worker is an independent contractor versus an employee. And similarly with the FLSA, it has its rules for overtime are applicable to certain types of employees. Some employees are exempt from overtime. And that is based on the reality of the work that they do. Similarly, they also have rules for independent contractors. The minimum wage and overtime requirements don't apply to those workers. And so the FLSA has come up with some guidelines to determine which of those workers are independent contractors versus employees. And I want to also state that the statutes that we're going to talk about tend to work kind of like strict liability statutes, such that if you are If a court determines that your worker is an employee or is not an employee, then those laws would apply to you. So if you have not been paying your non-exempt employee overtime, for example, you would just owe them overtime if the court determines that you have not been classifying them properly. You can't argue that they are actually not an exempt employee if the court finds that they are in fact exempt or not exempt. So there are a lot of risks that come with violating these laws, and so you want to be very careful to make sure you're following all of the different legal requirements. Next slide, please. But aren't we exempt? As many of you probably know, there are certain exemptions for religious entities. You're exempt from IRS and FLSA requirements to an extent. There's what's called the ministerial exemption, and this comes from the First Amendment. The government said, and the courts have upheld, that the government can't tell religious organizations how to organize their religious-based teachings or religious-based work. So when it comes to ministerial positions, such as religious teaching or religious leadership or training, they're not going to have for example, the rules against discrimination on the basis of religion. That's not going to apply to a minister of a specific religion. It's rules about paying certain positions. For example, in the Catholic Church, nuns and priests do not receive payment, even though they may work for organizations and for things that a person not in that position would get paid for. The courts have held that the government can't mandate that the Catholic Church start paying out people for their work if that traditionally is not what they have done. So depending on what the religious tenets or the traditions of your religion, there may be certain positions that are not paid or are worked on, say, a give in kind basis. And so those positions would be exempt from certain of the tax requirements and certain of the FLSA requirements as pertain to overtime or a minimum wage. As we've discussed in previous webinars, religious organizations are subject to IRS requirements as 501c3s. There are limitations on what they can and can't do, as we discussed in your political speech. So there are ways that the government has said, well, if you are going to take a benefit from a certain law, that means the law can regulate you in a specific way. And so that's just one example of where that exemption reaches a limit. Next slide, please. And then the FLSA has no specific requirements for any religious organizations. It doesn't make a carve out for religion. And so the courts have held that the FLSA applies to any organization that fits within the statutory scope. So there's FLSA coverage. One is enterprise coverage, meaning that if the business meets these specific requirements and earns a certain amount of money, then all the employees under the business are covered by the FLSA. And so that will cover employees of businesses with business of at least $500,000. And the regulations state that donations, membership fees, money raised for charitable activities will not be included. And so if you, say, earn $1 million or so in donations from your constituents, that doesn't make you covered by the FLSA. It only applies to those activities done for a business purpose. So if you sell things, if you provide services for a fee and you raise enough money that way, that could bring your organization under FLSA's enterprise coverage. And even if that doesn't apply, certain individual employees are automatically covered by the FLSA, regardless of whether their business is covered by the FLSA. So that will be for employees who work in interstate commerce, engaging in or making goods for interstate commerce. And for charitable organizations and religious organizations, that tends to be the outreach related stuff. So making and receiving calls across the country, shipping materials, transporting property. These things could, employees or workers who perform these tasks could be covered by the FLSA. So that is something to be on the lookout for, that even if the whole organization is not covered, there are specific employees who are covered and who must be paid overtime or must be paid a minimum wage. Okay, next slide, please. So what are the worker classifications? We're going to be talking about a number listed here, and all the key to all of them is that they're based on the worker's relationship to the organization. So we have volunteers who, work for free. They give their time willingly, and they don't receive payment. Independent contractors who provide work maybe for a larger variety of clients, and they own their own business. And employees. And of these employees, there are two types. There's exempt and non-exempt employees, and the exemption is from overtime. So that'll be an FLSA based requirement. So next slide, please. Who are volunteers? Volunteers are very important to any religious organization. They donate their time for free. Most important thing to learn, but however, there are many IRS and FLSA concerns. Because sometimes people or organizations try to use volunteers as a way to offset, some of their financial or requirements to pay employees. So the FLSA regulations say that you cannot have volunteers that will displace or do work that would normally be performed by an employed worker. So and we're going to go over some hypotheticals in the future, but if you have a job that is normally paid and that person can't do it for some reason, you cannot have a volunteer fill in to do that work. That is paid work. They need to be paid for doing that. For the IRS, note that when you give cash or give money to an employee or a worker, you have to report that. It can become taxable wages. I know apparently it's often to give volunteers gift cards as appreciation for what they do. However, certain cash items, especially the larger the gift card, like if you're giving out $1,000 gift cards, that could be something that needs to be reported. The IRS has suggested in those instances that is a big enough sum that you would have to report that, and then you would need to make a decision: is this person an employee or an independent contractor? Because you're not allowed to pay volunteers, and so then you have to go through the IRS's analysis. And so be careful about that, because that could turn just someone volunteering their work then becomes, or a gift for someone volunteering their work could become wages that you then have to report and also pay taxes on. And then back to the FLSA concerns, volunteers can't perform commercial activities, so it's not acceptable to have a volunteer working in, say, the gift shop or doing sales. And most importantly, paid employees cannot volunteer to provide the same services that they are already employed to provide. And so kind of similarly to that first mini hypo, if someone is supposed to be teaching 5 days a week and you want them to teach 7 days a week, you can't say, can you volunteer 2 days? It's either all employed or it's all volunteer, all paid work or it's all not paid work. But it's not something that you can't turn an employee into a volunteer. Okay, next slide. And who are independent contractors? That's the next big bucket we're going to talk about. What an independent contractor is going to depend on the law at issue. Most notably, what an independent contractor is not an employee. So any of the obligations you have to employees under state and federal law would not apply to them. They would have their own separate rules. The general rule is that independent contractors are independently contracting. They are independent. They are free from control. They can control the terms of their relationship with you by virtue of contract, whereas your employee has to agree to the terms of the employment. Both the IRS and FLSA have different tests that look at different factors to determine independent contractor status. And I will note that the federal government has gotten a lot stricter about looking at independent contractor status, because some employers in the commercial realm especially think that if I have a contract with someone that says they're an independent contractor, that makes them an independent contractor, even though I dictate the entire terms of their employment and they have to wear my uniform and they have to represent my company. And as you can see, they have to basically be an employee. that the courts are no longer allowing that, and the Department of Labor is no longer allowing that. They're very strictly looking into whether people are being paid properly, because whether they are based on whether they are properly classified as employees versus independent contractors. As I mentioned, we're going to talk about the IRS and FLSA, but some states have different tests. I know California and New Jersey have something called the ABC test that looks at a different set of factors, and California courts have a different analysis for determining what is an independent contractor. But it's very important to have that, to have an understanding of that. And so it's especially in states like California or New Jersey, which have very complicated employment law schemes. You want a California or a specific state law attorney who can advise you on those tests. Next slide, please. Sorry, next slide, please. Thank you. Okay. A little bit before. Okay. I think it's one more before. Okay. So we'll start with the IRS test. And the IRS, because it's simpler, it has only three factors, but a number of questions within those factors. First is behavioral control. Who does the potential employer exert behavioral control over the potential employee? Financial control, same question. And then relationship of the parties. What's the relationship between the worker and the organization? Okay. Next slide, please. Okay. So the behavioral control factor looks at how much your mosque or organization controls worker behavior. So if your answer to any of these questions on screen or that I'm going to discuss are yes, that's going to lean more in favor of an employee. So does your mosque provide instructions to the worker, setting the time, place, and manner of accomplishing a task? Do you tell them what to use or give them an order or formula to follow? Do they need to follow the employee manual? Do you give them specific procedures to follow or indicate specific methods? Do you care who does the work? Can they choose to hire someone else and pay someone else to do the work of their own volition? For the last one, if you don't necessarily care about that, that means they're more of an independent contractor. However, if you are controlling their tasks, or you're giving them tools to use, or the more and more control that you are exerting over that worker, the less independent they become, and the less likely it is you can claim that they're an independent contractor. Next slide, please. Okay, first little pop quiz. So question 1, Samir is paid to come to the mosque and help on weekends. The mosque requires him to work on site and provides a computer for him to use. Does the mosque exert behavioral control over Samir? I'm going to give you a couple of seconds to type in the chat. And let's see. All right. Okay, and then next slide will have the answer. And the answer is yes. We don't necessarily know what he does in this hypothetical, but we know he's required to work on site and he's required to use the mosque computer. So they are at least controlling that much. Normally an independent contractor may have their own tools, they may have their own specifications. Think of it, you're hiring someone to fix your air conditioning. They know how to fix air conditioning. You don't have to give them the air conditioning tools. You don't have to give them the way of how to fix the air conditioning. They know exactly what to do. Okay. All right, next slide. Okay. The second factor is financial control. Has the worker put in a significant personal investment into the tools, equipment, or facilities to use the job? So that gets just to my previous example. If the worker is buying their own equipment, using their own money, they put in an investment. It's almost like it's their own business. Does the worker maintain a separate office from the business? Does the worker bear the risk of incurring a financial loss in doing the job? So normally if an employee does a bad job, you can discipline the employee, you can terminate their employment, you can take a number of actions, but you can't not pay them for the work they did. You can't do that. You can't dock their pay because they did a bad job. You can't take them below minimum wage. If an independent contractor does a bad job, you could say, this is not what I asked you to do. You breached the contract. I'm not paying you. And that worker then bears a risk of loss because they didn't do the job correctly. That's what that factor means. Are there any unreimbursed expenses, and does the worker hire and pay work helpers? Does the worker advertise or maintain a visible business location? Is the worker paid a flat fee? Yes to any of these questions suggests that this person is more of an independent contractor because they've maintained their independence and maintained their financial independence from the business. Next slide, please. We'll do another quiz. All right, we're back with Samir. The mosque provides Samir with tools, a computer, and desk space for him to work. He cannot maintain a separate office, and he cannot hire and pay any helpers. Does the mosque exert financial control over Samir? Please type into the chat. Okay, and then next slide. The answer is yes. So again, there's more. Not only is there behavioral control, Samir is not bringing his own money into the work that he's doing. The company is giving him the tools and the space to work, and Samir doesn't have the ability to use his own finances to be separate from the business. So yes, the mosque is exerting financial control. Okay, next slide. Okay, last factor is the relationship of the parties. So what's the relationship between the business and the worker? Is there a written contract specifying employee status? This is always helpful. However, as I've mentioned, this is not the sole determinative factor. A lot of people are employees without contracts. Not enough people write things down. And frankly, a lot of independent contractors are also employees, even with a contract. However, this is just one factor that provides evidence one way or the other. Does your mosque provide the worker with employee benefits? Can your mosque terminate or discharge the worker? Can the worker leave before the task is completed without becoming liable for non-performance? Is the worker's service a key aspect of your mosque's regular business? So these basically tie. The more important the worker is to the business, and the more control that the mosque has over that worker, then the more likely they're an employee. I want to highlight the factor, can the worker leave before the task is completed without being liable for non-performance? That is similar to the financial loss. A relationship with an independent contractor is a contractual relationship. So when there is a problem, it's a breach of the contract. When there's an employment issue, there's a different set of employment laws that apply. And so that's why it's very important to know who your independent contractor is versus who your employees are, because the laws are not the same. And the remedy for any breach or any poor performance is not going to be the same. Okay, next slide, please. Okay, Samir does not have a written contract with the mosque stating he is an employee. He does not receive benefits because he works part-time for an hourly wage. He can stop working whenever he wants, but he and the mosque agreed he will give notice because his skills are essential to the organization. Does Samir's relationship with the mosque qualify him as an employee? Please type into the chat. This is a bit trickier, but okay, next slide. Okay, and together these factors would qualify him as an employee. He doesn't have a contract. So that factor doesn't sway anywhere. He doesn't receive benefits, but that's because he works part-time for an hourly wage, and none of those workers receive benefits from the mosque. Samir can stop working whenever he wants, and he's not at risk of non-performance. However, he agreed he will give notice, and that's something he's not necessarily required to do. But if he and the mosque have a relationship where they agree that he will behave basically like an employee for termination, that's more evidence in factor in favor of holding that he's being treated like an employee. Okay, next slide, please. Sorry. Okay. Different question. So Sara runs a halal catering company, and she's hired by the mosque to provide halal meals to students in its after-school program. She has a contract to provide meals for the 2024 to 25 school year. The only specifications are that the meals be religiously compliant. She may prepare her meals in her halal kitchen, and she's free to contract with other organizations to cater halal meals. She also advertises her services on social media. Should the mosque treat her as an employee or independent contractor? So we've gotten some answers in the comments. And next slide, please. Correct. Independent contractor. She has her own business that she advertises for. She's hired for a specific term of work to do a specific task. The only requirement is to do something that she already does. She runs a halal catering company, so it just has to be halal and compliant with this mosque. She has her own space, and she's free to contract with other people. That means toward her being an independent contractor. Okay. And next slide. Okay, I'm going to pass it off to our department head, Christina Jump, who will go over the factors for under the FLSA. Okay, I'll get us started with our first factor. The FLSA has a six-factor test versus a three-factor test, and these factors somewhat overlap. But the FLSA will look at all of them together, and of course, no one factor is determinative or has more weight. So the first one is opportunity for profit or loss, depending on managerial skill. That's a bit wordy. Simple truth is, can the worker negotiate pay or decide whether to accept or decline work to expand their business? Basically, does the worker have to exert their own managerial skill to earn an income, earn more or less than what they work, versus being a good employee and like working for a specific time before you get a bonus? That would be the difference. An independent contractor provides services directly to their clients. They make their own advertising. They negotiate contracts. They decide which jobs to perform to grow their business. They decide whether to hire work or to do all the work themselves. An employee can't do that. An employee provides services as directed by the company. They can't ask for additional work. And they only, like I said, only earn more by working more hours or meeting some bonus requirement.
There we go. Thank you, Chelsea.
No problem.
Okay, so I want to just step in and give Chelsea a moment to catch her breath. I appreciate that. And so I'm going to go through some of the factors, like she said, for the FLSA, for independent contractors. I know she just ran through this one, that the first thing that you look at, the first one of six, Chelsea just ran through. So if we could go to the next slide, then I'll go through the second factor. Perfect. So here, if we look at the second factor and looking at the economic realities test, does the worker make investments that are capital or that are entrepreneurial in nature? For example, does an independent contractor or worker will purchase their own tools? They get their own supplies, their own, honestly, literally tools of the job, tools of the trade that they can do. They invest in their own marketing. They rent their own space, even if it's like a shared office space, but they rent their own space. And they may occasionally provide services to the same firm, but they are in charge of what they accept, what they don't accept, and they are in charge of making sure that they have what they need to have in order to do the job. It's not provided by the employer, as opposed to an employee. If an individual worker is an employee, then that individual will be exclusively providing services for the one company, for the one employer. And that employer will provide the tools and the space and handle all marketing, and nothing is out of pocket from the individual worker. So the worker may occasionally use their own preferred tools if they wish, but they don't have to. They will be provided tools to do the job, and the employer is not going to fault the worker for not having better tools or not having more tools on their own that they procured on their own, because there's zero expectation that they would get any on their own, and that they would provide that themselves. So again, this is where basically the things that are necessary to do the job, is that provided by the worker or is that provided by the employer? So that's basically the summary of the second factor in the economic realities test. And if we can go to the next slide, please. And for the third factor, then this one looks at the permanence of the working relationship. So it looks at the nature and the length of the relationship. With an independent contractor, the worker performs work that is sporadic, it is project-based, it has a fixed ending date, or at least fixed ending measurable action. It may be when the project is complete with an anticipated date, but there's a fixed end to the work. And the worker performs work for multiple clients based on the decision to market to multiple clients. That's all up to the individual worker. So there cannot be a non-compete involved at all with an independent contractor. If they're an independent contractor, then they absolutely have the right to go work for anyone else they want to work for. And that's completely up to them, as long as they can still meet the requirements of the scope of whatever they were hired in that contracting role to do for the employer. If the worker is an employee, then the work does not have to have a fixed end date. Now, again, they could be a temporary employee, but that's still an employee. They could be a seasonal employee, but that's still an employee. But they perform work exclusively for one venue, for one basically employer, one entity. That is at the specifications and to the specifications that are set forth by that one entity. So they're working for one company, and if they're doing exactly what the company explains, and again, as we said before, that would be using the tools that are provided by that one same entity. So note that, again, while some work is seasonal or temporary in nature, short-term jobs for many employers don't automatically mean independent contractor status. So if somebody is hiring, like you see a lot of seasonal employees who are hired for work to do, like say in retail, at the busiest times of years for retail, then that individual is still an employee, because the terms of the work are still being set by the employer. They're still being set by the entity. So when and where they do the work, when and where they show up, and any tools necessary for that worker to do the job that they're hired to do the function that they've been hired to do, is all set by the hiring entity, and that makes them an employee, even if it is short term, even if it is seasonal in nature, or just to get through a particular busy time period. So we could go to the next slide, please. All right, so the fourth factor here is the nature and the degree of control. So assuming that there is control, how much and how is it exercised? Who controls the work performance and the economic aspects of the relationship, of the working relationship? That's something to consider here. So for example, here we would look at whether if the worker is an independent contractor, then the worker is not supervised by the entity. Here we're talking more specifically about mosques. So not supervised by the mosque. The worker markets services to obtain work from other clients. And the worker sets the worker's own prices, and the worker also would be possessing a flexible schedule and the ability to set that schedule. So not necessarily like, oh, you're coming into work in the mornings, you're going to be here from 8 to 12, you're going to be doing these functions. That makes the person more of an employee. With an employee, by contrast, then what happens is that the worker performs work exclusively for the mosque. If we're talking in the context of a mosque, otherwise, whatever entity it is, the hiring entity sets the work schedule and determines what the assignments are, and also supervises the work and can discipline the worker. That's controlling whether the worker can perform work for outside other clients as well. So does this worker have a right to say, for example, I'm going to perform work for you, but I'm also going to perform work for 3 others? Or do you have, as the hiring entity, do you have the right under the agreement with the worker to say, no, you're not. You're performing work for us, and you're going to do it on these days, at this time, something like that. So that's something to, again, to take a look at, to consider, how much of control is there? There's always going to be some amount of control. So I know when we say the control test and who exercises control over the manner of the work, it's not 100% absolute. As with an independent contractor, there can't be any degree of control exercised, because of course you're going to specify what you want done and what you want the ultimate result to be, even with a contractor. But if you are setting the hours, the days, the times, and prohibiting outside other work, then you don't have a contractor, you have an employee. So that's one thing to look for there. And so if we could go to the 5th slide as well, or the next slide, we'll carry on with the 5th factor to consider in the economic reality test. Great. So on this one, again, what we're going to look for next is the extent to which the work is performed, the extent to which the work that is performed is an integral part of the business. So how important is it to the core function that the business does? Is the work critical and necessary and central to what the business does and to the business's primary principal purpose? Because if so, that's not an independent contractor. That's going to be an employee. If these are your key people, it's unlikely that your key people are going to be independent contractors. An independent contractor can perform non-religious work, accounting, technology, custodial work, IT. That's a big one that often happens. And then an employee, by contrast, performs work that is essential to the mission of the hiring entity of the employer. So if they're doing the thing that you advertise that you do, then that's going to be far more likely, and this is a pretty heavy weight on this one, that's going to be far more likely to fall into being an employee who's performing the work that is your central focus of your organization, as opposed to being an independent contractor. So if we can go to the next slide then, and we'll look at, perfect, the last of the 6 factors here. The 6th one is look at the skill and the initiative that's necessary to do the job. So does the worker use specialized skills that take planning and that take effort in order to perform the work or to grow their own business? An independent contractor will use skills to perform the work and generate their own new business, not necessarily from the same entity. An employee, however, doesn't make decisions beyond what does it take to get the job done. This is the assigned job. This is the assigned work. What does it take to get the assigned work done? And that's the difference between an employee and a contractor. So your contractors basically are going to be always hustling. They're going to be looking for where they're going to get their next contract job, who they're going to get their next contract job from, whether it's from you or it's from another outside source. And so take a look. Take note too, though, that it doesn't mean like just that it takes skill, because you can have highly skilled employees if that's a key part of your function, and if you control the work, and if you provide the tools and all of the other factors that we just talked about. They can still be employees, even if highly skilled. But if they are highly skilled and able to market themselves outside, and able to take jobs from others, and able to do the work on their own time frame within the scope that's established, like if you give a completion date, they got to get it done by a completion date, but you don't care how many hours they work on any given day within that frame, because you're not paying them by the hour. You're paying them by a flat rate typically, or by a completion rate. So we could go to the next slide, please. All right, so let's see if we can apply these here. On this slide, And go ahead and put your answer in the text. I'll read it out loud, but if anybody is reading ahead, you're welcome to go ahead and put your answer into the chat. And also feel free to put any questions that you have in the chat as well. And then we can get to those at the very end when we're done. As we go through, if you have any questions for us, which I'm sorry I meant to add earlier, go ahead and drop your questions into the chat and then we'll come back to them. But for right now, if you have an answer to this pop quiz question, feel free to drop it into the chat as well. Mujahid is an IT specialist. He works at a mosque. He has an office at the mosque where he stores his equipment. He has to check in with management daily, but he largely directs his own work. Based on whatever the needs are of the mosque. He does not have a particular project or a fixed end date for his work, and he doesn't advertise or provide IT services to other businesses beyond the mosque. So, should the mosque treat Mujahid in this situation as an employee or as an independent contractor? Which one do you think that this is going to be? Is Mujahid, the IT specialist here, going to be considered an employee, or is he going to be considered an independent contractor? And I'll give that just a few more moments before we flip to the answer. We don't want to do that quite yet, so just a few extra moments for anybody to type into the chat. Okay, then let's go ahead and go to the answer. And the answer is employee. Right, and I think I did see one pop up there. The answer is employee here. That the Mujahid would be an employee here. He has a highly skilled job, and so that would weigh potentially in favor of being an independent contractor, but it's not definitive. That alone isn't going to do it. So even though he's highly skilled, he goes to the mosque to work. He stores his equipment there. He has to check in with management on a daily basis, though he largely directs his own work based on whatever comes up that's needed. But it's whatever comes up that's needed for that mosque. So he figures out his own way to get there, but the mosque will present the problems to him that he needs to solve. And he doesn't have a fixed end date, and he doesn't have a fixed scope of a project for the work that he's doing. He does not advertise. He does not provide services to anyone else. Now, it is possible that he could be retained as a contractor, but not with the expectation that he would check in every day on site. That's going to be likely to throw it off. That's why actually remote IT people are pretty popular, because you're not controlling what they do. You're not controlling where they do it if they're doing it remotely, and they can proxy in to try to address anything. So this would be, in this situation, Mujahid would be an IT specialist. It is possible to create IT contractors, but not with these facts that we have here in this quiz. So if we could go to the next slide, please. All right, one more. With Khadija, Khadija is a teacher, and she works full-time at the mosque, Monday through Friday. Her lessons plans are dictated by the mosque. She does not teach at any other schools, and she doesn't advertise for any other classes. Is she going to be an employee or an independent contractor under the FLSA? And again, go ahead and feel free to type your answer into the chat, and we can take a look at that. And I'll give people just a few more moments here to go ahead and type in. All right, so on this one, if we can go to the next slide, we'll get to our answer. And Khadija is an employee, right? So Khadija is very much an employee here. While it does take a specialized degree to be a certified teacher and presumably meeting the requirements of whatever state where the mosque is located, she's working full-time Monday through Friday. That's a full-time job that implies an employee status. She works at the site, at the school, at the mosque. Her lesson plans are more or less dictated by the mosque. Now, she may have some flexibility, let's say, in how she's going to answer questions, how she's going to decorate the room, but what's being covered is dictated by the mosque. And she doesn't have any other employers, and she doesn't advertise for the ability to teach other people. There can still be an independent contractor, even if they don't happen to have others taking them up on their independent contractor skills. So again, as with many of these factors, unfortunately, it's not like an absolute flat-out definitive touch, but understand that these are the factors that weigh toward one or the other. These are the factors that weigh in favor of, and it is a balancing test of most of them combined as to whether this is going to be an employee like Khadijah is, and like Mujahid was on the previous example, or if this is going to be an independent contractor, which they both could be if the circumstances of the work arrangement were a little bit different. And so let's go to the next slide. Okay, so the mosque wants to increase the educational services that it provides. So it asked Khadijah to teach classes on a Saturday, in addition to her Monday through Friday schedule. The mosque does not have the resources to pay another teacher. They don't want to bring someone else in. So they're asking Khadijah to volunteer to teach on Saturdays. So is it permissible for Khadijah, who is a Monday through Friday classroom teacher, to be able to voluntarily provide Saturday services for the same mosque? Is that something that she can do separate from teaching the Monday through Friday school? Let's presumably say that there are going to be separate students who would be here as well. Go ahead and type your answer into the chat if you have a guess here. And I'll give this just a couple more seconds. Okay, so let's go to the next slide. We'll get to our answer here. Absolutely not. This one's not borderline at all, not questionable at all. She is a teacher, and she is employed by the mosque as an employee, and she provides her teaching services to the mosque as an employee. And so if she's going to continue teaching on a sixth day of the week, even though it's not necessarily to the same students, even though it may encompass a different lesson plan, she's still doing the same function, and she's still providing a teaching benefit to the same employer. So asking her to volunteer her services on a Saturday is going to be a problem. It's going to get the mosque, or the masjid, or any organization into trouble, whether profit or nonprofit. It'll get the organization into trouble with the Department of Labor, because it is a violation of the Fair Labor Standards Act. An employee cannot volunteer for extra hours of their same job function. Okay, so let's go ahead and go to the next question, the next slide, please. All right, and so here I'm going to, as soon as Chelsea Glover joins us, I'm going to hand it back to Chelsea. There we go.
Thank you, Christy. All right, so we're going to talk about, the last section will be on what are exempt versus non-exempt employees, and this has to do with overtime. The FLSA determines who is entitled to overtime, and that is, the distinction is non-exempt employees earn overtime, exempt employees do not. And overtime is time and a half. So if you work over 40 hours, any time over that is time and a half, and that it has to be paid at what you earn plus a half. So exempt employees do not receive this overtime. However, to be exempt, you have to meet certain tests set by the FLSA. In most cases, this will be because they are paid at a certain level such that the government doesn't feel like they need to earn overtime for any of that extra time they worked. It's one of flashing lights. Most employees are non-exempt. The overwhelming majority of employees are not exempt. If they, the only ones who are exempt are the ones who meet the qualifications. If they do not meet those qualifications, they are non-exempt, and they need to be treated as non-exempt employees and therefore paid overtime. So the three tests to be exempt, there's the salary basis test. So that means that they're paid on a salary basis, not paid hourly. So if you have an hourly employee, they're non-exempt. You can also be paid, at least we'll get to the highly compensated employees. There's some distinction between being paid on a fee basis, but the FLSA has specific regulations as to when a fee meets the same level as a salary. In most instances, it will not. The courts have recently held that, giving, or you may have heard of something called a day rate, where people would pay large sums for 2 weeks of work and then they'd be off for 2 weeks. They said that's not a salary. Even if they're being paid, six figures, they're not being paid a consistent weekly amount. And that's therefore not a salary. Then there's the salary level test, which means you have to earn a minimum per week that's set by the Department of Labor. Right now, today, it's $844. January 1st, next year will be $1,128. So if you're not paying them, which comes out to roughly about $28 an hour, so they're increasing the level to be exempt because they want, they believe the more, the government's saying we want more people to be non-exempt and therefore paid overtime. So it's going to be a higher salary level to meet. Finally, there's the job duties test. And not only do they are paid on a salary basis and meet a salary level, they have to be performing specific job duties. These are called executive, administrative, or professional job duties. And we'll go over those in a second. And so they have to meet all three of these tests in order to be exempt unless there's another separate law that applies. I want to flag something called highly compensated employees. These are employees who earn at least 130 or the set amount a year. So right now it's 132,964. On January 1st, it'll be 151,164. If they earn that per year, and that can be on a salary or a fee basis, but they have to earn that per year. And they have to perform at least one of these EAP job duties. So at least one executive, administrative, or professional job duties. And that's just because they're paid so much that they don't feel, the government doesn't feel they need extra protection for any of the time over 40. Okay, next slide. Okay, so the first, we're going to talk about the different job duties. The first are executive job duties. The primary duty of someone in this position, and it can't be a side duty, it has to be a core duty of your job, is to manage a recognized subdivision of the enterprise. Emphasis on recognized. It has to be something that people commonly know as a subdivision or that your organization has labeled a subdivision. It can't just be you have two people that you manage sometimes, or that you tell what to do, but they're not really a subdivision. They're just people that you happen to know or people that you're close with. It has to be you are the leader of marketing. That's your executive position. You are in charge of raising money. That's your executive position. You have to direct the work of at least two full-time employees. So it can't be two part-time employees. They have to be two full-time equivalent employees. And you are directing their work. You have to have the authority to hire and fire, or make suggestions as to any suggestions to their employment status. Your suggestions have to be given a particular weight, that are the executive employees. So it can't be, so maybe we all, give our thoughts on who can be hired and fired, but the executive's thoughts may overrule others. Maybe they can override the consensus on whether to keep someone around. So that's, be your CEO, your executive manager, those kinds of jobs. But as Christy and I've mentioned, we have to look at the reality of the situation. It can't just be what we describe it as. They're going to be looking into those job duties and say, okay, where's your hierarchy? Where's your line that says you're actually managing your employees or managing a business or a subdivision? So all that to keep in mind. Next slide, please. Okay. The administrative job duties, the primary duty has to be performing office or non-manual work that's directly related to the management or the general business operations of the employer. So that's tends to be what you think of as administrative work for any business. So your accounting, your human resources, IT, safety and health, public relations, things that keep the business functioning, keep it running and operating. Management, of course. You may not be the executive, you're not the head person in charge, but you are in helping keeping it running. And on top of that, you also have to exercise discretion and independent judgment on significant matters. That means you can't be directly told what to do. This is something that trips up a lot of people in commercial, where you're paying people to do specific jobs, but the employer does not have any room for independent judgment or discretion. It's just if X, then Y, if Y, then Z, things like that. That will make that job less administrative, even if it's office work, even if it would fit into that, because they're not expected to exercise independent judgment on any significant matter. The courts will say that's not an administrative job, and therefore they're not exempt. Professional. This is for work that requires advanced knowledge in a field of science or learning. So this normally requires a degree. It doesn't always require a degree. It can also be knowledge you get from either specialized instruction. So you could have done an apprenticeship for a number of years and become an expert in your field, and that may make you a professional. It doesn't have to be a 4-year degree. You can be a professional technician and do it in certain or limited number of years. But of course, if it's something like, for example, lawyers, doctors, those are all fit under the professional exemption. Next slide, please. I want to highlight 2 specific professional exemptions that may be applicable to mosques or religious organizations. One is a teacher. Teachers are considered exempt regardless of their salary, the salary level or the salary basis. Those two tests do not apply as long as their primary duty is teaching and instructing and lecturing, and they're employed and engaged as a teacher in an educational establishment. So that kind of goes to the having a teacher certification or being a full-time teacher in a school. It does not apply to employees engaged to care for the physical needs of children. So daycare professionals are not exempt. If you're looking at babies or just making sure that they're safe, that's not a teacher. Then we also have the creative professional. A creative professional, maybe you have a musician or maybe you have an artist on site or who works for the mosque. They do have to meet those salary requirements to be exempt, but any work requiring invention, imagination, originality, or talent, design, for example, things like that, that could make them exempt under the creative professional. Maybe not necessarily, advanced learning, but it's creative. So that's how that would work. All right. And then I think, next slide, please. All right. And that's our last slide. I'm going to let Sana close us out, and then we'll take some questions.
Thank you both so much. I feel like this was probably one of the most substantive webinars we've done. There's just so much information on this topic, and I know you guys could probably spend another hour on just these things because it's so nuanced. So with that, I will just start with some of the questions that we've gotten from participants, and either of you feel free to jump in and answer. So the first one is, what if we contract that people cannot work overtime, but they're slow and they do it without permission? Do we still have to pay overtime for work that we did not approve?
I can go ahead and take that one, and the short answer is yes, you do. The statute is, the Fair Labor Standards Act specifies suffer or permit to do overtime, which is a weird phrase, but basically if they did it and you didn't send them home before they actually did the hours, even if you were unaware that they were doing it, once they've done it, you have to pay them for what they did. So you do have to pay them the overtime. You also can write them up for having done it without prior approval, but that's not, you can't take money away as discipline. So payment of wages cannot be withheld based on disciplinary action. You can write them up and you can say, if you do this again without prior written permission, then you'll be fired. And you can do that. You can fire them for that if that's a clearly communicated policy. But you do still have to pay them even for the hours they work that end up getting them ultimately fired.
So then you'd recommend that someone has to kind of monitor these employees in order to kind of maintain their hours and things like that? You don't have to monitor, but that expectation needs to be clearly laid out.
The expectation needs to be clearly laid out of the need to get approval in advance. And in an ideal world, there's somebody who's monitoring to some degree, at least looking at the timesheets as they're turned in, whether they're turned in on a daily or on a weekly basis. And then it can be addressed as soon as that's visible, as soon as it comes to the attention that anybody did it.
Sure. Great. So next question, why is it so important for organizations to keep track of how everyone is classified? There's a couple parts to this. What are the potential consequences of misclassification? And have you seen that? Have you seen mosques or other nonprofit organizations actually get in trouble for this? What was the outcome?
And I could take the first part of that. Something that it's similar to what Christy mentioned, like the laws are not forgiving for employers in these circumstances. They are, it's designed so that if an employee comes within the protection of these laws, they are entitled to them. And so if you're found to have misclassified your workers and your employee, that person sues saying you didn't pay me overtime, even though I worked all these hours, and the court agrees with them, you don't have any other option. You have to pay that back. And there's extra penalties for not doing a good faith investigation as to whether they're properly classified. The law puts the burden on the employer to show why they thought that they were properly classified. And it certainly can't be, well, the employee said they didn't want to be that. That is not going to fly. I saw something like that. Well, what if the employee doesn't want to be paid overtime? It's like, the law says you have to be paid overtime. And if you're not paid overtime, then we're in trouble.
Right.
And so that's why it's very important to keep track of that and also continually investigate it. Make sure that if you're putting someone down as an independent contractor, that you know why they are an independent contractor, and you can show a court why they are an independent contractor, because that's the risk.
So I actually had another question just to follow up on what you just said, Chelsea. Would you recommend that, I know not all mosques or organizations have a dedicated HR person. So let's say it's the board of directors collectively who are interviewing and hiring someone. Maybe there's one person who's kind of the point person to write a contract with or negotiate with, something like that. So would that person from the mosque, would it be in their best interest to kind of list out those 6, let's say, independent contractor factors and like almost draft out what those factors are and kind of have something on paper to say, hey, we're hiring them as an independent contractor. Here are the factors that is that too much? Is that not enough? Is that something that you'd recommend for a mosque to do when they're hiring an independent contractor?
I'd recommend it. I think it's funny, like as a former employment attorney, I mean, that's a lot. I wish our former clients would have taken that initiative and done that work on the front end. Of course, that's why you hire lawyers, though. But yeah,
Right.
Doing that on the front end saves you so much time and effort on the back end of having
Sure.
to defend against the charge. So
because then it kind of at least gives the mindset of, okay, here are our intentions as a mosque. Here's what we're hiring them for. And if they go through those factors, maybe on the front end, maybe things will change. And that's why there might be litigation later on. But at least in the beginning, maybe to protect the mosque a little bit, to say, hey, this was our intention. And, for hiring the independent contractor. So guys, save those factors, write them down. And if you are hiring an independent contractor, make sure you're looking at the factors and not just one, but kind of collectively. I know we're 2 minutes out, 2 minutes over. Let's do maybe one more question and then we can wrap it up. So the last question, well, actually, sorry, Christy, I don't know if you wanted to add anything to like the potential consequences of misclassification, or if you have seen any mosques or nonprofits who've gotten in trouble for this.
We definitely have seen nonprofits get in trouble for doing this incorrectly. And one of the biggest concerns, as Chelsea mentioned, to follow up on what she said, is whether the error, the misclassification, looks like it was done in bad faith or in good faith. So having a job description in advance and making sure that the job description matches what the employee is actually doing, and that it doesn't just have all sorts of fancy proper words, but it's actually what the person is doing on a day-to-day basis, is really important. The kinds of things that can come up is that the employer can go back, not the employer, the Department of Labor can go back up to 2 years, and if they think that it was an intentional or willful violation, which is especially going to come true if it was like a mass misclassification of multiple people in a category, or if it's something that you've gotten in trouble for before. It's come up before and you should know better by now. If it looks like it was a bad faith violation or done intentionally, then they can go back 3 years to collect. And I have yet to meet a nonprofit that has accurate payroll records for what workers did and how many hours they worked going back 3 years if they didn't expect to pay them overtime at the time.
Right. Okay. So great answer. Thank you so much. Okay. So next question. Which we've kind of talked about, but what if someone doesn't want to be paid hourly and get overtime? If they request being paid on a salary, can we do that? If so, how should this be solidified, like written or verbal agreement?
Definitely a written agreement. That's always what I'm going to say. If you want an agreement that'll stand the test of time, you definitely want to write it down. That probably can be done to be paid a salary and let me just look back. I think they don't want to be paid hourly, but they still want to get overtime. Okay. Yeah, you could do that. It's just it probably won't meet the same salary level. It probably won't meet the same like yeah, it won't be a set salary thing. As long as it's above minimum wage or at or above minimum wage, it is fine. The exempt, remember, you have to meet all the rules of exemption. So if you don't meet any one, then they're just not exempt. So if they're not exempt, then they get overtime. That's kind of,
Yeah.
you can do anything as long as you don't unfortunately force them into those three exempt categories. And then and again, like, I guess that's kind of bravery, but like, as an employer, you don't necessarily want to pay overtime. So if they don't want to receive overtime, then right. But if they do want to receive overtime, then they need to make sure that they are not exempt.
Yeah. And I would just add to that, to wrap up real quickly, that if an employee just simply says, I want to be paid as a professional and with a salary and not have to keep track of my time just because I feel like that makes me feel more professional, and feel like I'm worth more, you can pay by salary, but paying by salary doesn't take away the entitlement of the job to being entitled to overtime. So you still have to pay attention to it. And that gets messy. And there's high math involved in that, because then you got to calculate what the hourly rate is so that you can calculate the 1.5 rate for any hours that are worked over the 40 hours a week. Also, bear in mind that employees do not have the right to waive their right to overtime. If the job duty is entitled to overtime, then that person's entitled to overtime. And I don't care if they sign something saying that they're waiving their right to overtime or they recognize they're not entitled to overtime. They're still entitled to it if they're entitled to it under the law and the application to their actual job duties. And if you've asked them to sign something saying they're not entitled to overtime when they are, then that's going to lean in favor of the bad faith evaluation that we talked about also. So watch out for that.
Yeah. Okay, so we're going to do one last question, and that is, what's the time limit for employees or independent contractors who change their mind and want to be employees to claim that they should have overtime for what they already worked? What's the time limit?
I'm not sure what the statute of limitations is on. I don't have that on hand, but I do know that you can sue for unpaid overtime that you haven't earned for years. I do know that.
It is generally, and there may be state laws that broaden it. So be aware of those. But generally, it is to go back 2 years, and then again 3 years if it's something where the Department of Labor determines that it looks like a willful or intentional violation. And so that's even if they say, I know I said I was a contractor and I agreed to that, but I felt like I had to, and really I've been doing work as an employee the whole time because they controlled everything. Well, then they can go back up to 3 years claiming for each week how many hours they now say they worked based on whatever they wrote down in their personal calendar or diary or anything that they may have, or just they sent themselves an email, or they don't have anything and they just write down a total and you got to disprove it. They can go back for 2, possibly 3 years for that.
Yeah. Well, thank you everyone so much. Please note this last slide here with our contact information. If you have any questions related to your mosque or your nonprofit organization, please reach out to the MLFA.org website. We provide a variety of pro bono legal services, like Christy and Chelsea are in our civil rights department. We have an immigration department. We have a criminal defense department, and then I head up the nonprofit department. So I help Muslim 501c3 organizations. But again, here's our contact information. My name is Sana Salim, and with me, Christy and Chelsea, we just wanted to thank you all again for joining us today. And we have one more webinar coming up in November, on November 11th. Please check that out. We'll send out links for that as well. But that one is about immigration and how there are certain visas for non-citizen religious workers, lawful permanent residents, aka green cards, things like that. Like if that applies to your mosque, maybe your imams and workers. So I think it's going to be really great information. Kate Brady, our head of immigration department, is going to be leading that webinar as well. And then that will round out this series of webinars that we've been doing related to mosques. We hope it's been really, really beneficial for you all. And we hope to see you on November 11th. Thank you again so much. Take care, everyone.
Thank you. Appreciate it.